One of the screens, or
Why don't we connect, can we connect it to this one?
yeah, you want.
Because we need the mics.
You need the mics, yeah.
Yeah, okay.
You want? Okay, I'll go with this one. Yeah. Okay.
Let's see if we can get more mics.
You want use the mic? Are you gonna be facing? Are you gonna face it that way, the people, or?
We're just gonna do a group table.
So we want the tables over here or back there?
Let me see.
You said 12 people, right?
Yeah.
And then I can put
Maybe
one
just
here, one there, and then two over here.
or connect this one.
Yeah, but this way, yeah.
So we don't have to move this, right?
No, I think you can move the mic.
Yeah.
You said 12 people, yeah. I'll just do one here, one here.
Okay.
See, if you're gonna be facing the screen, then you can put these on the side, yeah.
So we may not be able to start at 9, just saying.
Okay.
Let me see. I can put two here, no. Maybe 1, 2, 3, 4, 5, 6. Yeah.
One
You
here?
got two across,
Okay.
and then you can sit. Yeah? Or you want to be longer?
No.
Okay, yeah. I mean, you're not social distancing, right?
No.
Okay. Yeah, because
I wonder if we just put one in here, George.
if you want me to, but you want to put one right there?
Because I don't want to be too far from the mics. You know what I mean?
So you just want to put one in the middle?
You gotta connect it too, huh?
Yeah.
I think that'll be good.
That'll be good, okay. I'm going to leave the tables over there in case you do need one.
Okay. All right, and you'll do the chairs too?
Yeah.
Thank you, George. Appreciate it.
somebody to come down, or,
What do you mean?
for the workshop?
You know, I'm not sure. I don't really know that portion of it.
Okay. I wonder if anybody's gonna show up besides me?
I'm sure they will. We haven't, normally, they'll let us know if they're not gonna show.
Yeah.
No more tables?
I don't know who would want it, who had wanted tables.
And Janine's all like, set up the mics and blah, 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 and I was like, no. She didn't tell us ahead of time, so.
Set up the mics for the table?
You know how there was tables set up over there?
Yeah.
They wanted like more mics, that we're gonna have a round table thing apparently.
Oh,
So I had
we were?
to- That's what Janine told me, and that's why I saw the tables.
Shoot, I took them off because I thought that was last from yesterday.
She just told me that right now. Like, so I had to go scrounge up the microphones.
I mean, I took the tables off thinking that was set up from
No,
yesterday.
she asked me about,
It's so frustrating, honestly.
right?
They left.
I don't let people know.
Yeah, because it looked to me
It's gonna be a while because we have to set up some mics, we're gonna do a round table session.
It's supposed to start in 5 minutes.
It's gonna be a little longer.
I'll be back.
No, these things are heavy as fuck. These are monsters. How many people are in here? Yep, I get to a point where I'm like, you're worried about any of these people.
Buenos dias.
If I'm not organizing this, it would have been nice to know.
Yeah, right?
Because I'm telling you, I came in and it looked like it was set up like this from yesterday. Apparently we're sitting down here.
Oh, really?
No, 5 minutes ago.
We don't really know, I need to know so I can set up mics. Hey, wait, ¿sabes qué está pasando? Or not? Janine said to make a round
Is
table.
there any wanted us to have like a little roundtable session? Yes. 30 minutes is just a work session. So
To me, this is what they had set up. This is what they set up.
yeah.
Yes, Renee wants an informal.
But, Felipe, were you able to get mics or not?
Yeah, I mean, it's gonna take some time to set it all up, but, you know, if I would've known this yesterday.
Morning.
Yeah, he's notified us at 7 p.m.
Well, yeah, because I'm telling you, it was set up like this, and I go, this looks ugly. I'm like, so I thought it was set up from yesterday, so I came in and started taking everything off.
Rubio texted me like at 6 in the morning.
Yeah. You know, we can transfer, share mics, I mean. Let me see here, 1, 2, 3.
We probably need more tables.
More?
Yeah, she's small, so
But
commissioner.
Sargis is up there.
And Mel will be there too. You want one more this way, or?
Well, because we can sit over there, which means
Okay.
1, 2. No, I don't think we need more. Like, we have 1, 2, 3, 4, those, and this. Yeah. That other chair, they had it right there on the end. Or that rolling chair. No, they had those rolling chairs right here. I don't know. what that is, but- That one can go right there, to me, and then I'll bring.
Okay, are we too close? 3, 4, 5?
No.
And then we'll find the mics. Okay, did you make packets for everyone on this?
Yeah,
I got
they're
one.
already up there.
These are these yours?
How are you? We're doing our today. I shouldn't have said that.
That worries me, you know what that is.
Eventually.
The last time you said he has friends. I laughed about that for about a week.
I don't think it helps me not do anything.
Morning.
Wants an informal.
How you doing?
I
Yeah.
Yeah.
And we're gonna change the agenda.
We're all gonna have to really, really grill mom on this. Help do this, we'll do this next.
Kindly mess. Just those three trimmings and plus the view.
So is this not gonna be filmed?
Yeah.
Can they just listen to the conversation?
That's the best way I could describe it.
Zero. The deep
Okay, so
training.
I have a friend who's in America who actually watches that. Oh. And so we kind of have this and he's the one who actually goes, apparently there's some change in commerce now, and I went, and then they said, and there's, this woman who came up the street, and I went, I know exactly what you're talking about. I guess she's also very active.
Playing Wordle?
And as soon as he said, yeah, we're seeing it, I had to get out. Oh, okay.
But it wasn't the zoning.
So that's the last minute thing I.
I just drew them.
Just plug it, all those together, plug it, this guy out.
Good idea, but we need a work order for this.
Just like a day's notice.
But we're managing, oops. So, we'll get started. And we wanted to change the order of the agenda to talk about cannabis first.
One of
Do you want that one that's close to
I don't
the
think,
area?
we don't have,
No, like, those won't be good here.
Okay. So this one
no,
we can,
Yeah,
it's not.
these things are often direct, shoot at everybody.
So, Albert prepared a presentation for the
Kind
hearing
of
and
take
so
it down, that's a big while, don't trip.
and so we think the amendments to the decisional criteria will hinge
when you
on.
got a smoothie from Javier, too,
And
but
then also, don't forget that SUP decisional criteria is not only for cannabis, it's for all other species of weapons. And we're getting a.
You watch the,
Solar farms coming for solar. And we're allowing them by SUP if they're in T2.
other than that, I don't really.
So, but they're coming in for D1, D2 zones, and we're recommending.
I moved out because I was 5.
Why don't they just go for
Yeah, my parents, it was really young when they moved in there. But I would just go back to this.
CI1? Industrial zone.
Now it was just like her house.
So that's okay. Well, no, once the solar panels go away, then they can have a junkyard. So just food for thought. I don't know, maybe we could simplify it on the matrix too. We don't have them identified as solar farms, they're called renewable energy sources. Yeah. They're coming from the Midwest. Iowa, Minnesota, those are the two. I think we got 15 last week from one company, but they're just looking at the zoning right now. And then 8 from that, Cindy, the solar farm.
So where are they sending the energy from? So you're from here?
Yeah. We haven't got,
I mean, we were square miles, so, but we were waiting for the transmission line to come
We just all electricity in the world, we can't send it anywhere, that's good.
That's true, we haven't asked those type of questions yet. And they're going on 70, 80 acre parcels.
Yeah.
So close to transmission lines and all that, so.
Really?
Well, they're just scouting out locations now. We're gonna tell you.
Oh, no, do you want to need a special use permit?
Okay, do you want us a special use
Oh,
permit?
okay, I don't, that's not a lot right now.
Okay, so what,
They're, all of them, at a minimum, require a special use permit.
okay, then why was I getting the zone change to T2 and then a special use permit?
Because, you can't have a, D1 can have a solar facility.
Okay,
You have to get a zone change to I1, which is a use zone, or a T2 with a special use permit, which is a transit zone.
so I was on the right track.
T2 is the only option for that?
Or special use permits. And I think T3 as well, T3.
Or on I2 or 3.
Now we have to look at, okay, are we gonna have transit zones with use zones, or are we gonna have use zones and transit zones, because somebody might have, so talking to people, a lot of them, they're like, well, we don't mind, you know, having that restriction, if we do get it, saying that we're just gonna be for solar, I mean, that's fine. But then you get into contract, and there's still that kind of stuff, so. So these are
Big solar fields.
Yes.
I think the smallest has been, what, 30 acres out there?
But yeah, we'll just get a request for 15 parcels.
And then it's surrounded by residential. So what kind of buffer do you require? But it is intrusive, the solar panels.
Where do you want me on this?
Feel
Well, yeah, that one.
aesthetically, you know.
Solar field north of Las Vegas. There's one, well, I swear, it's not like some culture next to the lake.
No.
It does, looks like a lake. So you get a little closer, you can, it's probably 40 acres. Yeah, you gotta get some. Been there for 4 or 5 years.
I probably did see it then.
They must know that there's a.
Yeah. Are most of these in south part of the county?
Yeah, they're south.
The new owner.
But they don't,
Okay.
yeah,
Oh, well, within a year.
And if they're, okay, so if they're up and running. Questions. And then they sell it. Reapply when it's golden.
uh-oh. I don't think we can keep this on.
So it's been, sorry.
I'm blaming it on Mel. Wow. It's in stereo.
Dolby.
All I could really, yeah. Nothing's been done. I don't think we made that special use permit to the owner.
Unless the new owner wants to do a particular use, it might be more valuable to them, but I don't think it's.
I didn't put those shears to be that sharp. And that just went right in, just almost didn't hold the top of the finger off. Jeez. I was like, God, I can't even be trusted with pruning shears. Another injury cause.
Get you some of those fish cleaning gloves, you know, the ones.
Yeah, they have Kevlar gloves.
Yeah.
They, scissors won't cut through it.
Yep.
But so what I did is I put away the hand shears I bought with these.
There you go.
Oh, I can't get a hand in the way that way.
Test this one. See if it works, if it doesn't.
It works.
That one works.
I'm gonna have to start asking for reimbursement,
gas mileage reimbursement from Anthony to here. The way the gas is.
Or you could use the county transit.
Yeah.
I mean, you have to leave there at 6 a.m. to get here on time. I don't know what that route is.
Sessions look like there's nobody except just them right there, okay?
Yeah, at least they're somewhat distanced.
Are we on a party line?
But still,
You totally just dated yourself by saying the words party line.
That's true. I haven't heard that in 20 years.
As soon as I heard it.
Yeah, it brought flash memories back from when I was growing up.
It's like, it took me 5 years to learn to say aluminum foil instead of tin foil.
is Ernie there too? That looked like a bag of a ponytail.
Is that Cheryl?
Are we ready? You ready?
I think we are.
Okay. Mel? Mel? Can you hear us? He's there. Bill, can you hear us okay?
Yes, I can hear you.
Thank you. Cheryl? You okay?
I can hear you. Good morning.
Morning. And Mel? Okay,
Probably got it on.
I can hear you.
thank you.
He had to wake up.
I heard that.
That was me, so you can get me later.
I guess you should call the roll. It's an official meeting.
Commissioner Zargis,
Here,
Commissioner
electronic.
Commissioner Thurston, Commissioner Herrera,
Here.
Commissioner Montañez,
Here.
Commissioner Lear,
Here.
Commissioner Acosta,
Here, electronically.
Chair Zarniak.
So you want to, since we don't have any cases, I think that, Janine asked me if you could flip the agenda so that you could hear about cannabis establishment regulations first, huh? And Albert, you have a presentation?
Yeah. And also Cheryl here from the Office of Engineer. She's here to answer any questions in regards to water rights.
Great. Okay.
I don't, we can't turn them on.
I tried turning them off. I just couldn't do it.
I think we should just unplug it if it's gonna be like that the whole time. And we might just share that. Let me see, let me try it real quick and see.
You can go up there and speak. Okay.
Cheryl?
Yes.
Hi, well, we're going to switch the agenda a little bit. We're going to have the cannabis establishment regulations. We're going to talk about that first. But at the end of our packet, we did include the FAQs that you guys provided the public. We had a few cases 2 weeks ago, and there was some discussion on, the difference between somebody who wants to grow cannabis outdoors versus somebody who wants to grow cannabis indoors, like in a greenhouse. And, what kind of, what the differences are with those in your office, what kind of water rights are they going to be needing, commercial versus irrigation water rights? So we just wanted to see if you can clarify that for us during this part of the work session.
Okay.
And I don't know if the commissioners have any, any questions in regards to that.
Mr. Chair?
Well, I have a question. Like in Anthony, we have our own, well, there's a private provider for water and sewer and stuff like that. And there's about 3 outfits that are gonna be getting their license to sell cannabis and stuff like that, and even medical cannabis. But on the water rights, what do they have to do? Just go and talk to the water company and said that the water company is gonna provide enough water for their plants? Or do they have to go through a special procedure?
What they'll need to do is get a letter from the water company, whether it be, I'm thinking, is it City of Anthony, for instance, or the City of Las Cruces? They will need to get a letter acknowledging that they will provide water for that specific use. And they will need to provide that with their documentation to the, I guess it's the RLD up in Santa Fe.
Okay, thank you.
And there's a specific, I don't know if you folks have seen the application that is submitted to the RLD, but what happens is we get that documentation in our office, and the district manager or one of the other folks here in our office will verify that indeed there's a provider, whether it be a valid water right or a letter from the water provider.
Okay. One more question, if I may.
Sure.
As I was last week and part of this week, I've been making my rounds around Anthony, and I've seen a lot of small greenhouses going up in private residence, and some of them are like 10 by 15 or 6 by 6, different sizes. Who's going to control that? Our police department has said that they're not going to be going in there and investigating and all that because it's up to the state. So is the state going to be sending state police or investigators or whatever and coordinating with the police department in particular municipalities, or are they just going to go in there and do it on their own?
Well, can I speak to that? What we're doing is, it'd be good if folks see that they can go ahead and write a letter to us and let us know that that's occurring. Those folks will have to have a valid water right. And of course, that's whether they have a proper permit through the license through the RLD, that's a whole different matter. But what we have is it's called the Lower Rio Grande Water Master Group, and they're going out and making sure that these folks have a proper water right.
Well, what I'm saying is that if it's for home use, I mean, not for resale or anything like that, but if they're just growing it for their own use, do they have to have water rights until, or just tap into their water lines that they have to irrigate the plants that they can have?
Well, we're taking the position that no water, it has to, let me back up, it has to be a commercial water right regardless of whether it's personal use. And RLD might have a different perspective on that. But if someone has just a regular domestic well, we take the position that they don't have a proper water right to grow their cannabis.
But they can use the water provided to them at their houses by the waterworks.
Well, again, they'll have to have the proper documentation through the RLD, and we'll have to have proper documentation that they have permission from the water provider.
I'm still a little confused because one of the classes that I took online, well, one of them was actually before COVID and the other one was during COVID, Zoom. And they said that people growing for their own personal use they just go out there and start growing a plant or 2 or 3 or 4 or whatever the limit is, and they didn't have to apply or do anything like that. Is that still the rule, or do they still have to apply?
Well, from our perspective, that is more a question for the RLD. And so I can't speak to that as far as the personal use.
Okay.
Cheryl, just to clarify, so if I have a water well and I'm growing 6 cannabis plants for personal use, and I'm going to be watering those plants with that water well for my own personal use, do I still need a permit, or would somebody still need a permit from the Office of State Engineers for growing cannabis plants for personal use?
Well, we just respond to any kind of application that's forwarded from the RLD.
Okay.
So if we don't get anything from them, then we don't take a position on that at all. So that's I think we're more worried about the commercial use and the folks selling it. But as far as the water use and whether they need a license is a question really for the RLD, I think.
Okay. And then, Cheryl, if another question now, what is the difference between somebody who's growing outdoors? So let's say somebody applies for a micro business grower's license, and they're growing cannabis just as an outdoor crop. What kind of license would they be required to obtain from your office versus somebody who's growing the same, number of plants, but inside of a building or a structure of a greenhouse? Can you tell us what those differences are?
Sure. We're taking the position that if it's outdoor use and it's just like a regular crop, whether it be alfalfa or corn, they can use their EBID surface water. And if they have a groundwater component combined right, they can certainly use that. So we would just consider that to be a regular crop, again, like, onions, alfalfa. However, if they are using a specific hoop house, the consumptive use of water is different. And so we're taking the position that they need an actual commercial water right. They can't use their domestic well, and they can't use their EBID surface water or irrigation groundwater. It has to be a specific commercial water right and permitted through our office.
For a greenhouse.
And just to clarify, you're talking about greenhouses and hoop houses, right?
Correct.
Albert, Dan has a question. Here, Dan.
So let's say somebody's got a greenhouse on their property, but they're not growing cannabis, they're growing tomato plants. That's, to me, that's the same thing. But there's no requirement to have a commercial license for me to grow tomatoes in my backyard.
Right, and that's an interesting dilemma, but that's what the state engineer, those folks up in Santa Fe, that's the position they've taken. So if you want to grow tomatoes, well, let me back up. If it's a commercial tomato growing, you'll need a commercial or a valid irrigation water right for outdoor use. But if it's in a hoop house, again, you'll need a commercial water right. And I know maybe that doesn't necessarily make sense, but that's the position they've taken up in Santa Fe.
So when you say commercial, what if it is strictly for personal use, just like somebody's garden would be for personal use? I guess it's, to me, that seems unenforceable. There's people all over the valley that could be growing 1 or 2 plants in the middle of their tomato plant and patch. Nobody would even know it was there except the grower. So it seems to me it's almost like it's a requirement that's unenforceable.
Right, and I think there's some confusion about, for instance, a domestic water right. A domestic water right can be used indoor use and a garden, ornamental trees, that sort of thing. So if someone is growing a couple cannabis plants with their tomato plants, then that's part of, that falls under the domestic well permit.
Okay. I'm still not sure I'm clear on this.
Tell me, what question do you have? What's confusing?
I'm trying to figure out, have they separated growing cannabis from growing anything else? Is that a separate topic? I mean, because people are growing all kinds of different plants in their yards, and even in small greenhouses, they're growing things other than cannabis. But it seems like if it's all for personal use, I guess I don't understand why you would treat cannabis different than any other thing that you'd grow for personal use.
I see what you mean. Well, we don't. And again, if it's a small greenhouse just for personal use, and a person can use their domestic well for sure, but any kind of, yeah. So whether it be, some folks have pecan trees on their 1 acre, and we take the position that they can't use their domestic well because it's commercial. And I think that's the biggest delineation.
Okay, so the delineation is between personal use and commercial.
Correct, exactly. So whether you're selling, again, let me back up. If someone has an acre of land and they have a lot of pecan trees, it's pretty obvious that they're selling those. Okay. And so we've taken the position that they have to have a valid irrigation or commercial water right, correct?
Okay, all right, thank you.
You bet.
Cheryl, Albert Casillas, one more question. If somebody right now wanted to obtain the water rights, what timeline are they looking at from your office? So somebody who wants to do a commercial establishment, greenhouse for, I don't know, 4,000 plants, and they need to transfer some commercial water rights, what kind of a timeline are they looking at right now?
Well, first they have to file an application with us, and it's a change location of well, place, and purpose of use. And that filing fee is $50. There's no, for a permanent transfer, there's no emergency provision for that. What they'll have to do is file that application. Then we assign that application to one of our specialists. And there's a requirement to publish notice in either the Sun News or the Las Cruces Bulletin. And that has to be published once a week for 3 weeks. And the public then has 70 days to protest that application. And then we can't act on that application until after that 70-day protest period has passed. Now, there is a provision for leasing. It's under the leasing statute, and a person can file that application, same $50 change location, well, place, purpose of use. We need a lease document that's between the two, the seller and the buyer, or the leasee, leaseor, and that needs to be accompanying that application. And if we do a preliminary evaluation to make sure there's no impairment to local wells or the river, and then we can issue that lease but that needs to be published also. So you could lease that water and start leasing it once we issue a preliminary approval, but that application can still be protested. So, and if that occurs, then all the protests go to our hearing unit and that lease will have to stop. So we're talking probably at least, probably 90 days until we can even, well, let me back up. It'd probably be about 70 days before we could even act on the applications.
Okay. Are there any more questions from the commission?
Mr. Chair, Mr. Chair,
Yes.
it strikes me very strange that the people in Santa Fe that are growing all these things, right? It doesn't appear to me that they know what the heck they're doing. Truly. It's a big mess. I feel that there should be, well, first of all, how many plants are you actually allowed without having to have a license, number one? We need to find out what is the irrigation water rights, like EBID, right? Municipal water rights, okay? Domestic well water rights, define those and the actual use instead of this permit and this and all this other stuff. I think they need to go back to the drawing board and redo a lot of this stuff. And I don't know if you commissioners agree on that or not. It confuses the public, it confuses us, and we need to have something in place that is actually, that we can put a bite on it. I mean, if you don't do this, you gotta do that. If you don't do this, you gotta do that. And that's, I don't think that's correct. I think that it confuses the whole issue, you know, and they should go back to the drawing boards and they should do it correctly where it's definite. And in the event that we have to have enforcement, then we have a good grasp on how we're going to enforce it. And some of the questions that Albert posed as part of the addendum, they were very good questions in enforcement, like on outside smoke or whatever, you know. And so I look at it this way. This thing is a mess. And they need to do something where, like, look at Cheryl. She's coming in here and she's telling us about all this stuff, which is great because they conjured this stuff up in Santa Fe. And that's great. At least we have something to work on. Now we need to tweak it some more where we can get it more finite. And I don't know if you folks agree with that or not, but I'm sure that we're trying to save Cheryl here from all this confusion, you know. That is horrible. I don't think it's right for the general public, and I don't think it's right for any county or municipality in the city, in the state of New Mexico. And it's not fair for the people that are trying to grow a business, and I think Commissioner Thurston would agree that. We need to make sure that we have definite policy and establish a rule of order, and that's what we should go on. Instead of all this googly gawk, we're wrapping our cord around the axle. Nobody knows what the heck we're going to come to screech and roll.
Mel?
Yes.
Before you go on, did you have any other questions for Cheryl?
Well, yeah. I had so many questions. I mean, I'll just let her go and see what else she has to say.
All right. Bill, did you have any questions?
No, I tend to agree with Mel that the information we're getting is confusing and contradictory, but that's also the reason we're having this workshop, is to try to get that somewhat resolved, or as resolved as best we can right now. So thank you for being here, Cheryl. We appreciate it.
Oh, you're very welcome. And this is new to us too. And there's really a huge level of frustration because we get a lot of folks coming in and filing applications and they don't understand it. And a lot of these folks are very pushy and they're very passionate about what they're doing. So it's taken up a lot of our time. And so our frustration level is high here as well.
Anything else? Okay, we don't want to take your time unless you've got questions. Anybody else?
Okay. Cheryl, thank you for coming in today. You're more than welcome to stick around for the rest of the presentation, but I think everybody else here, got their questions answered. Is there a contact number for you where in case if somebody else has any more questions, that they can reach you?
Yeah, you can reach our office at 575-524-6161. And I have a lot of folks here, we call them water resource specialists. You can just state your question and ask them, but if you have a specific question, the commissioners, you can certainly call me. But the general public, I like to have them just talk to our specialists. And my extension is 1019 if you folks specifically want to talk to me.
Thank you, Cheryl. We appreciate it.
You bet. And shout out to Sean. Go Alabama, huh? Okay. Cheers. Thank you.
Bye-bye.
Thank you, Cheryl.
Bye-bye.
Felipe, can we go back to the PowerPoint? Okay. And then just to continue with this discussion, I'm just going to give you guys an overview of cannabis as it relates to some of the D districts that we have, the D1s and the D2s. So this first part, on the previous, on our last hearing, there was some discussion about, and concerns about minimum lot acreages and sizes for micro business producers, specifically in the D2 and D2L. And then as part of this talk today, we're also going to be talking about some of the regulations that we have for T4 zoning, just to clear up some language so there's no confusion. And I'll talk about that towards the end of the presentation. And of course, we heard from Cheryl today. We did try to get somebody here from RLD, but there was no response from them. So, but they were sent the link and the link to the hearing and everything. But we did try talking or getting Robert Zaks, who's their policy director, to see if he can make it. But
remind me what RLD is.
That's the. So it's basically the state office in Santa Fe for cannabis.
You don't have to worry about that. That's the difference between a professor and a helper.
So let's. I gave you guys a copy of the PowerPoint just because I knew you guys were going to be sitting up here on your regular spot. But this first slide right here, this is, if we go back and look at what the P&Z recommended to the Board of County Commissioners, we're going to look that on here, it's pretty much empty on the D2s and D2Ls. So basically saying that if a cannabis microbusiness producer, if he wanted to operate out of the D2 and D2L or any of these zones, he wasn't going to be able to. He was going to have to get his own change ad and go through the appropriate process. That's what, this commission recommended to the Board of County Commissioners. So, you fast forward a couple months later, to where we actually, had to go to the board, and this was the final outcome. And from what I recall, and Christina can step in as well, was that they felt that cannabis should not be treated any different than any other crop. So in their mind, they felt, well, if somebody has an ACT designation and if they're in DM or D3, they can grow any crop, then they should be allowed to grow cannabis. So that was the outcome of one of the many outcomes or compromises, if you want to.
Go back there a second. This is what the BOCC said.
This is what's in our books right now, yes.
Am I having a disconnect with what the lady from the water just said? That if it's grown, if I'm planting corn, I don't have a problem. But if I'm planting cannabis, I have to have a separate water right? Where's my brain separated there now?
For commercial purposes, and I'm sure they have their own regs for growing commercial corn
Yeah, but
as
if I
well.
got my 40 acres out in the valley right now
Yeah.
and I plant corn, I don't have to have a separation of the water right.
Mhm.
But if I understood what I heard from the land office lady, I have to have that as a separate.
That's what it sounded like.
So we're not, this is getting more confusing in
Well-
my mind. So now I gotta go, if I've got 3 acre feet on my 40 acres today, and I plant alfalfa, I can use my 3 acre feet. Now I switch and I'm growing cannabis. I'm not growing alfalfa, I'm growing cannabis.
If you're
But
growing
I
it-
have to separate,
No, if you grow it outside, it's okay. That's what she said. So if you just plant rows of cannabis outside,
just like I would corn.
right, you can use your EBID or groundwater for that purpose.
Commercially?
Yeah.
Okay.
Yeah.
And private.
But if you go inside,
If I now put a greenhouse over it,
right,
I now have to separate that out?
you have to have commercial water right, which is different.
But,
I think that's the
well,
same.
so I
for
don't
any
have,
crop.
I don't have
It's the
the
same
water.
thing?
For any crop in a greenhouse.
Oh, okay, okay. So it applies across the board.
That's my understanding. Correct, Albert?
Can I not grow lettuce?
Outside, yeah.
No, in my,
in
in my greenhouse
For commercial,
for commercial.
then you need a commercial water right.
No. Well, then then I violate the law, so I guess I might as well just.
You are exactly right. You violate the law.
So you're selling the lettuce?
Well, absolutely, but that has not been. If
I hope
if
you're
I'm-
not giving away trade secrets.
No, I'm just saying
This
that
is-
it happened.
This is a friend of yours, not you.
No,
right?
no, this is me, but I'm no longer doing that, so I cannot be held accountable for past sins. But, thank you. If something is wrong in my head. If I'm an onion
I agree.
grower, what do I do to get my onions ready for planting? I don't go out there and just plant it in the field. I have those started in a greenhouse. I use my water from the EBID well. I irrigate that in my greenhouse. And I have my 5 acres of onion plants. I then take those out, and I'm planting them in the little cubicles. I take those and I have my guys go out and they plant them now in those rows. I'm violating this water right? Growing onions that way? But or am I okay doing that, but now I can't do that if I do that with cannabis?
That's a good question.
You raise a different question.
Well, you guys caused me to ask that question.
No, it's a good
Because
question.
the separation,
Right.
I don't think that's a valid, I don't think you will win in the court telling me that I can't grow my starts for my lettuce and my onions all the way through my chili. I mean,
I think how they're looking at it, Mr. Fish, not to interrupt, is, sorry, if you were to do a hoop house and start your
explain
start,
what a hoop house is.
it's a PVC. Oh, sorry.
Can we hook up one of these items that we can pass around?
Yeah, we can, it's gonna need that echo.
Maybe just one.
Okay, maybe the
With
white
the
one,
long
cause
cord.
the white is the long.
I think part of the reason it's actually
And so close to.
Just whistle, what's a hoop house?
Thank you, Eileen. I wish.
Going through my brain.
So they can be made of PVC or wood, and it's kind of a dome shape with just plastic over the top of it, which you can remove or depending on the time of year. So that's a hoop house, or a lot of times farmers use the shade cloth certain times of year not to harm that. Those don't require permits through RLD permitting.
Okay.
But what they're talking about is an indoor grow that's just specifically for indoor growing plants. I think that's from the stuff that I've heard and how they're looking at it is an indoor, you're starting your onions in a greenhouse. Then you're transplanting those onions outside to be grown, correct? So you're starting them here, so you're basically putting them outside, which you have the water rights for. The cannabis plants, most of them that they're starting in a greenhouse are in a controlled environment because they could control the water, the humidity, temperature, bugs, things like that. So the plants will be started and finished inside the greenhouse. I think that's how,
the separation.
that's how, from what I understand, how they're looking at it. Now, if you started plants in a greenhouse, your seedlings, just like onions, any crop, okay, and you transfer it to an outdoor grow, I think they're still gonna allow you, from what I understand, to use your water rights for that purpose, because you're not finishing the product indoors.
Gotcha. But now, in this scenario, if I am growing tomatoes, and I continue to grow the tomatoes in my hoop house, I call it greenhouse, then I'm violating the water right.
From what we understood from Cheryl, yes, because it's a controlled environment, commercial grow.
I've been educated.
But if it's 12 plants or less for his commercial?
12 plants or less is personal, so 12 plants or less is not, it's for your personal use, you're not supposed to sell the product for that.
Okay?
All right, so yeah, I mean, I added these slides up here just so we can see what happened or what the difference was between, you know, what the P&Z had recommended and what the BOCC ultimately adopted. So basically opening up the door for anybody who's in a D2 to, and if they're not assessed as ag, that they would also be allowed to get a special use permit.
Albert, just, because we've never really talked, the T5 is really the core of those small villages.
Mhm.
So they're,
Mr. Chair and Albert, just to clarify here, it does say permitted if assessed as agriculture for on-farm operations only. An SUP is required if not assessed as agriculture in those zones.
Yes, and then that's why, you know, the case that you heard 2 weeks ago from Mr. Tafoya, you know, they were able to apply for the special use permit because if they're not assessed as ag, so now they have to come to this board for the SUP.
and they were a D2L?
D2L. So let's keep on. Okay, so moving forward, I had Frank Dodd from GIS come up with a couple of maps, and I'll be breaking everything down. This map right here, and it's also included on the packet that I handed out. So everything here in green, it's D1, D1L, D2, and D2L combined. So these are the existing zoning designations that we have for D1 and for all the D1s and the D2s. And then, so Mr. Dodd went ahead and ended up separating those parcels that were zoned for D1 and D2, and then identifying which ones were assessed as ag. So here we have zoning for the D1s and the D2s, and these are the parcels that are currently assessed as ag by the assessor's office. And just looking at this map, then we can see that everything up on the East Mesa, you know, north of Highway 70, there's nothing out there assessed as ag. So we can look at the Del Rey area, kind of where, you know, Mesa, Jornada, and then going all the way up to Holman. A lot of those properties are not assessed as ag. If we break it down a little bit more, if you just look at the D1s, we can kind of see that most of the zoning designations out there for D1 and D2 are mostly D1. And then, of course, here are those assessed ag parcels within D1. And then if we go down to D2, of course, you know, this being city limits right here, then we can tell that, you know, not as much as D1, but, you know, there's still a few parcels out there. You know, we can look at, you know, the Picacho areas. This is the Del Rey area where the Tafoyas kind of live. Doña Ana, and then kind of like west of Tortugas in that area down here, south of Mesilla. But when we look at the assessed parcels for ag that would allow for a grower, they're pretty minimal.
So what does that map tell me?
Well, one of the questions was, how much D2 is out there? How many potential special use permits are we going to get coming in here?
And that's on that side.
Yes, so these would be all the D2s. So potentially anybody in this area on the parcels that are here in yellow, if they're not assessed as ag, then potentially they can come in here and request a special use permit.
So somebody in Focaccia will.
Absolutely.
So I'm not sure if there's any kind of forecast here for how many special use permits that we're gonna see, but we only saw 2 in the first hearing, or in our last P&Z meeting. How many are you expecting now?
I'm not sure. I know there are some in the works right now. I do have some for retail that are going to be coming down the road. Those are just because of distancing requirements that we have to residential areas. So those will be coming pretty soon to the board. But special use permits for growers at this point, I don't have anything so far. There was also a request to talk about T4s in the county. So basically, transects T4, you're going to find them mostly on the old town sites, Salem, Rincon, Rhodey. So you can kind of see here, that every little town site has some T4 in it. When we look at the southern portion of the valley, of course, San Miguel, La Mesa, Berino, they all have T4 within their boundaries. And here, we can just look at where those T4 parcels are located. If we look at Doñana, so this is down by Beta Road and Isaac Garcia, so kind of like a little bit west of the main town of Doñana. So you see that there's a lot of T4 there. Radium Springs, it's sprinkled, with some of the T4, mostly kind of like next to the I-25 and the exit. This is Rincon, a lot of T4, Rhodey. I'm just gonna say it. Most of it is pretty much T4. And Picacho, this is the village of Picacho, which, back when it was in the ETZ, it had that village district. Even though it was within the ETZ, technically it should have gotten a use zone out there, but because it was a village district, we just ended up giving it a transit zone. So pretty much all of the old town side of Picacho, it's T4. And that's going to be kind of like the same with Tortugas. It used to be in the ETZ, but it was a village district back then, so a lot of it ended up getting a T4 designation. Along South Main, we have Bracito, San Miguel, Mesquite. A lot of the Benino town sites zone as a T4 as well as La Mesa.
So are these the ones that we required the buffer for, the 300-foot buffer?
For retail, but there's a reason I'm bringing up a T4 right now, and it has to do with kind of like one of the amendments that we're proposing for this section, and I'll talk about it right now. But you are correct. Anybody who wants to do retail, there is a requirement of having to be 300 feet away from a residential structure. And why was I showing these maps? Right now, when we look at the current language of T4, basically leaves it open to anybody. If retail, so I'll read it as it currently is written right now in the code. If a retail business legally exists in the T4 zone, a cannabis retailer may be permitted without the application of an SUP, providing providing the county has issued a business registration at the time of this ordinance was adopted, and complies with all T4 development standards of this chapter. So, just looking at that statement on how it was written, it pretty much just leaves it open. It doesn't say that anybody has to comply with the 300-foot distance, as long as somebody had a business registration, it's pretty much, go for it on any T4. What we're trying to do with that, it's kind of say, okay, yeah, you do need an existing county business registration in order for that to occur. So we're just by adding the word "and has an existing county business registration," I think that kind of closes that door to allowing anybody who has a business registration within the T4 to start operating a cannabis establishment. I don't know if I'm missing anything out, Christina, on that, or if you have anything else to add.
Albert, so the scenario here, I could go just get a county business registration in a T4 zone, and then go ahead and set up shops, a cannabis retailer. I wouldn't need a special use permit in that case. Is that how I'm picking this up?
Well, you'd have to have or find an established retail business that was existing.
Okay.
Right?
So the business would already have to be.
Right, and I think we're deleting it there. It needs to remain in there, that had to have been established at the time the ordinance was adopted. That was what we put in there. And that was something that we had to do pretty much at the last minute when the BOCC heard this ordinance for the second time. And it was in direct response to public input regarding retail establishments that currently exist in the T4. And the BOCC did think it was appropriate to, they called it grandfathering. If you already have a retail business, then you should be able to do a cannabis business there. But we do want to make it clear that retail had to have been established already when the ordinance was adopted. So we'll need to amend that again, or rewrite that just to make it clear that it had to have already been established.
And being a commercial, already having a commercial business there, would there be any, would it specify what type of commercial business we're talking? Are we talking about a standard like a C3 with higher traffic, or would it just be any, commercial designation that was already?
Could be a restaurant.
It has to be a retail business.
It has to be
The way
retail.
it's written, it has to be a retail business.
Thank you. That helps a lot.
Can I ask a confusion here again?
Yep. They want you recorded.
Okay, you just showed a whole bunch of green in all of those counties, in all of those little cities, right? So if I have, now this is just an example. If I have a Dollar General that's established in, and I have 6 of those scattered throughout the valley. Now I can go in under that rule right there because I've already been established. Now I'm a cannabis retailer, and you guys can't, and we can't say a word about it. And all of that green is, okay, help me to understand what all of the green was then. What permitted that? That's a T4 zone.
Yeah, all those are T4 right now. But
Am I wrong in my, oh, you're saying that I can't put a Dollar General in a T4 zone?
No. What I'm saying is that most of the Dollar Generals are not in T4 zone. If a Dollar General is in a T4 zone already, it's currently existing there, then they could turn it into a cannabis retail shop. But this retail exception only applies in the T4 zone. So it would have to be a retail business that was already existing in a T4.
Okay, so let's say I had a restaurant and it's in a T4 zone, existing.
A retail is not the same as a retail establishment. If that restaurant had a retail component, then it would qualify.
So if they were selling tortillas, packaged,
Or burritos.
that's a retail.
Well, it is, but the primary use is restaurant.
One example that I want to give that everybody's probably familiar with, there is a restaurant right here in Avenida, Salud, that also built into it as a retail establishment.
Oh, yeah, next, right.
That would be.
That
probably
one
be
would
more
qualify.
example.
Yes. And I mean, we would have to make a determination if somebody came in with a retail, an established restaurant, and they made a claim that they had a retail component, we would have to make a determination whether or not that retail was actually substantial enough that it qualified for that exception.
So in many cases, with especially some of these older buildings, I just thought about La Posta's building that is leasing to retail shops, and I mean, there are going to be those cases
Can you go back
as this progresses.
to the code?
So it doesn't matter whether it's food, or what about a clothing store? What about a shoe store? What about a brick and mortar, like, what's the name of where I always go shopping now? I'm in, like Best Buy, it's not Best Buy. What is the darn things out in the county? That you can go buy all kinds of things,
Dollar
construction.
General?
No. What are they called?
Best value?
Like in
Hardware?
hardware stores. Yeah, True Value and Best Value. I can't remember the names of them now. There's one right there on south going out towards the valley there. But are those in T4s? I'm just trying to get a handle on what a T4.
Okay. Well, the T4, if you look at those old communities that really were developed with different standards than we see today. There's storefronts that are all the way up to the right of way. There's not typically a lot of parking included. And they're those very small communities that have already been built out. And typically those storefronts are small. I mean, you might see a case where, I really don't know, we didn't do this kind of research, where a bigger or medium-sized big box retail is there, like a Dollar General or True Value. I'm not saying that there might not be one located in T4, but I think it would be unusual because those areas were already developed a very long time ago. They're more of a historic community, which is why they have that designation.
I have a question for you. It says an established retail business. I notice in a lot of these small villages and towns, there are places that were retail businesses but are no longer functioning as that. They've been shut down for, maybe since COVID. So let's say it used to be a retail business but hasn't been for the last year. How would you handle something like that if somebody wanted to turn that into a cannabis retailer?
We did have one situation like that, and we will honor that if we can prove that it was established as a retail at some point prior to the ordinance being adopted.
Okay.
Can I give another example there? Okay, so in Hatch, on the main drag during the retail of chili days.
Mm-hmm.
So you have 6 or 7 different families there that have their various retail spots. Are those T4 zones the street coming into from the highway on 25 to Hatch, and then the old road going and heading to Deming? Is that T4 zones, or is that a different zone?
Well, Hatch is its own township with their own zoning regulations. So while we issue permits,
Village and
yes. So we issue building permits for them, but we do not apply our zoning to Hatch. But if you had a situation like that where somebody had a seasonal storefront related to their agricultural, that doesn't really count because it's not an established retail store use through the building code. As a farm, you are allowed to do your own farm stand on your agricultural property.
Okay.
But unless they have built a structure that was specifically for retail and designed to commercial standards, then that exception would not apply.
So this would essentially avoid
somebody with a seasonal retail establishment to be able to distribute cannabis throughout the rest of the year that it's not being used for seasonal purposes.
Right, that's correct.
And commissioners, also just remember that I don't think there's anything in the state code or cannabis regulations that would allow for like the outside sale of cannabis. You know, they have their own rules and it has to be inside a building and follow all the building codes and restrictions.
Well, I can seriously say that some of those in the Hatch area, they are year-round. You know, they take the chili, they process it, and then they retail that's frozen. And so those stores are open 365. So, but I'm just thinking that's got to be the same out towards Votto and down that direction. That they have their own retailers. But I'm going to have to get familiar with that so I know where to go buy some property, you know. So. How's that the greedy side of me? Gee.
And commissioners,
Interesting.
that's the end of this portion of the work session, unless there's any other questions that you guys have.
So are you recommending this as a change?
Yes. This is going to be an amendment to the cannabis establishment sections of the UDC.
And Christine, you're saying that the only thing you want to change here is to say established at the time that the code was created or approved?
Well, actually, the part that's stricken there, that's already in the ordinance. So it already says that. It says county has issued a business registration at the time of the ordinance was adopted. We're suggesting some minor revisions to make it a little bit more clear, but we unintentionally struck that part of it. So we need to actually reword it again to make sure that we keep that condition so that we don't accidentally allow somebody to establish a retail and then come in and apply for a cannabis.
Okay.
So, Mr. Chair, I would personally appreciate making sure that it is specific to retail only. I don't want to see, I wouldn't want to see a lower traffic establishment like a doctor's office or, something that didn't have as much traffic that all of a sudden does. I want to ask the commission this question. Should there, I don't know if there's a better word to use here. I don't want to say statute of limitations here, but if a retail business has not been functional after a year, I'm just going to say a year, should that be permitted? Should there be a limit on how long a business was not in operation before they can open up as cannabis retail? I just wanted to open up that discussion.
That's kind of what I was getting at, is that, because I know there were some businesses that closed down because of the pandemic, and that kind of makes sense. But if a business, let's say, closed down 5 years ago, and then somebody comes in and wants to turn it into a cannabis retailer, to me, that's not an established retail business at that point.
Well, you also have the requirement, they have to have an existing county business registration.
Right.
So if they don't have that in hand. So the place I'm thinking of is La Union Depot, right there on the corner. It's been closed at least 5 years. But that was an established business. If the owner of that building came down, picked up a business license, and then came in and said, well, I have an established business. It was there for 30 years. I have a business license. I want to open a cannabis shop, and I'm in a T4. What do? You say no? So do we go back to what Steve's saying and saying that it had to be established or in operation the previous 12 months?
I'm not making any suggestions to the timeline. I definitely want to just open that discussion up.
What do you think?
Mr. Taylor? Mr. Taylor?
I think it's a valid suggestion, and I don't have a time frame, but I think, a couple of years, maybe even 5 years. the way we look at it from the building code side is if it's been a retail use or any use, even if it's not operational, if no one has changed that use to something else, then they still maintain that use. And so I was kind of looking at it that way. I mean, if the retail store has been closed for, who knows how long, if there was at some point a valid business registration, then we were going to honor that because the use hasn't changed at that location, even if it has not been in operation. But we are willing to consider a time frame. I think within 5 years would be reasonable, but I mean, that's really just, it's just a number. I mean, we're open to suggestions if.
So you're also looking at this from the perspective, I almost hate to say it, but from economic development, that you have this vacant building that 4 years ago closed. Somebody picks up a business license, now they want to put a cannabis shop there. Well, why not? Okay.
And also keep in mind that there is required a distance between cannabis establishments, and that is not subject to an exception. So if somebody opened their retail business, cannabis business, somebody within 300 feet could not also apply that exception because somebody else already beat them to it.
Does that apply to a business that's inside a municipality and somebody in the county level opens up another one and still has to be within 300 feet?
That's a good question. It hasn't come up yet.
It's coming up pretty soon.
Okay.
It should have, why wouldn't it apply?
Yeah, I mean, it technically should apply, but they could make the argument that.
There's a couple of, Albert Casillas, there's a couple of things that might play. For example, if one municipality has a distancing requirements of 1,000 feet, but then the other municipality has a distance requirement of 300 feet, then what prevails? So I would think that at a minimum, what should be applied is state regulations first, and then whatever jurisdiction has authority over that property. So if the municipality, if the property next to it, had a 1,000-foot distancing requirement, but then they're going to be 300 feet away because that's what the other county requires, and they're meeting state code, I don't see anything wrong with that. I don't think they'll be in violation of anything.
Okay.
That's how I'm looking at it.
Mel, did you have a comment? I thought I heard.
Can you hear me?
Yep.
I just had, going back a little, I was going to ask Albert, do we have any historical districts under T4?
I don't know, Mel. I don't know if you're looking at the PowerPoint right now, but basically, pretty much every town site, Chamberino, La Union, all of them, that I'm showing here on the PowerPoint, in some form or manner, there is T4 on pretty much all of the old town sites in the county.
What about the like in Mesilla? I mean, they have their own zoning, right?
Yeah, so Mesilla, they're their own jurisdiction, Hatch, Anthony, and the city of Sun and Park.
Okay, thank you.
Bill, did you have anything?
No, I'm just listening right now. This is all, most of this discussion so far has been pertaining to transect zones. And I remember back when we started working on the UDC, we talked about, the consultants were talking about us having too many transect zones and that many of them need to be readdressed. Now, this isn't the proper work session to get involved in that, but I think it's something we need to put on the calendar for down the road, is to take a look at those T4 zones. A lot of this confusion wouldn't be there if we. That's all. Thank you.
Thanks. Okay.
Albert, this question's for Albert. Is our transect zoning really the only zoning that you feel staff is having a few issues with? Or
No. Pretty much, well, I mean, we're probably gonna get a good idea maybe, 6 months or a year down the road to see exactly where we're at, but right now, these amendments, or the amendment that we're proposing right now is just to fix something that we see it's gonna be troublesome, in the near future. Somebody who pulls a business registration because, they have a mom and pop shop, in the middle of Salem, and now, they're gonna be able to start selling cannabis, even though they're just surrounded by residential dwellings. So we're just trying to take care of that issue right now. And then, of course, one of the other reasons we're having this presentation was also kind of to address the criteria for D2 and D2L, see if we were going to come up with any regulations on that. So that's why, I know we were talking mostly about transit zones, but, I think we should also probably touch base on that and see if either through this, part of the work session or the one that's coming up next with Janine, if we can address some of those issues.
Because I know Dr. Zerniak was concerned about the T2 and the minimum lot size for cannabis establishments in T2.
D.
D2.
Oh, D2, yeah.
D2.
D.
Yeah, I wanted to ban them. I mean, I don't see it.
And-
Not for commercial. For commercial growing in a D2, that makes no sense to me at
Absolutely
all.
not.
Unless they have the acreage,
Yeah, yeah,
an acre or more, I think is kind of what you were leaning towards.
yeah. But the one case, that was an acre, right?
The first case.
And that was a D1,
Right.
right?
Yeah, so the problem with D2, it's, most of those are D2 because, they either had a ER4 or ER5 zoning back in the day, which those weren't 1 acre lots. A lot of them are gonna be either 3/4 or half of an acre, or even smaller than that. So, when we did the comparison, on the PowerPoint, there's really minimal, amounts of properties that are assessed as ag right now in D2. And basically, it's probably because they don't meet that 1 acre requirement to be assessed as ag.
So the question is whether the BOCC would accept that as a limitation
Yes.
under 1 acre. D2 under what? Can you be D2 and be above 1 acre? Yeah,
You can,
but there's probably hardly any of that at
I
all.
don't know. I mean, we can have Frank do that query and see if there's any out there that are above 1 acre. But I'm sure there's probably gonna be really, really minimal.
well, actually, Picacho Hills, I think, is, the majority is zoned D2. And there's a lot of
1 acre
1
lots.
acre or greater parcels like that.
But-
That comes to mind.
Yeah, one of the reasons they got a D2 and D3 zoning out there is because they were zoned for ER7. Back when the ETZ was there.
Mr. Chair?
Yes,
On I-10 eastbound, the dairies, what, was it under village districting when they zoned that up there? I mean, not zoned it, but they cut it from a 5 acre to a 2 acre parcel or less?
A lot of the dairies around Basel, I believe they're I-1. They ended up getting I-1. They had I-1. No, before the UDC, they had a PUD type 2, I believe, for industrial. And then when we did the UDC, they specifically, a lot of those owners came in and they specifically requested an industrial type of zoning. And I think it was mostly because of financing purposes and that kind of stuff. But they ended up getting an industrial designation.
Mr. Chair, Janine, do you remember when we went to those meetings down there at the Del Cerro Community Center?
Yes.
What happened there? Did they establish a different kind of partition of those lots?
No, it was approved under the Vado Community District. That area was within that community district pre-UDC. And then when it came over to the UDC, we map zoned it. And I believe those are mostly D2s out there, right, Albert?
So it's one of those rare instances where you're gonna have use zones out in the middle of the county. So a lot of Vado, like Estancia, and well, the main Vado area, the residential area, it's mostly D2 out there as well.
And they're wanting.
What about, Albert, what about Alto de las Flores? Oh, what is that?
Alto de las Flores, I'm not sure. I don't remember off the top of my head.
Well, there was just west of the illegal subdivision that was there, of Vado. Between Vado and San Miguel.
I don't recall, but Janine seems to think that it might still be a transit zone out there. I don't have Vado out there. Oh, Mesquite. Yeah.
Which way, down?
Yeah, the Mesquite area should be transit zones out there.
I hate to even bring this up. How did we get these isolated lots?
thinking the same thing. How did that happen?
As T4? Do you see them?
Yeah.
On the east side of Mesquite? Yeah.
Somebody drew a line.
Either somebody drew a line, or there was like an old PDNR maybe out there.
I think you did that, right? You just went in and did a different.
That was like a residential neighborhood, that one out to the
Yeah.
east.
Yeah, on the one on the east there.
So I'm thinking there's already a commercial use on there.
Or you think?
Yeah.
Cannabis location.
I'm ready. I'll be leaving the route about 10 minutes. I don't even know where that is, so I'm in trouble.
All right.
Mr. Chair, Albert, I don't believe that that we'd be able to come up with a solution for D2 and D2L in just one work session. And I appreciate definitely opening up the discussion. I just don't know where exactly to go from this, this meeting.
And
Has there been a staff recommendation? Has there been any kind of staff analysis on where we should start?
Not
D2 and D2L.
Not at this point. I guess that the first stab of at that was, kind of like with the conditions that we came up with, the previous cases that we heard. Thinking about lot sizes and maybe depending on the lot size, restricting that to the number of mature cannabis plants. The reason I wanted to show the comparison of the P&Z recommendation to what the BOCC ultimately came up with was because I knew that there was going to be maybe talk about taking an amendment where we were going to be banning D2L and D2 from having cannabis growing on them. But we tried doing that the first time, and they came back saying no. If we can't treat it differently than ag. So
They basically just kicked the door open. That's what they did.
I think it's my concern, my general concern has always been the vicinity to higher density residential in this. And so it definitely would be a pretty in-depth discussion that could go on for a very long time before any decisions made on D2 and D2L.
And I guess one of the good things to look at is that at least there is that requirement of a special use permit. So, we do have a little bit of control on, what we can allow there, how many plants, if we can impose any type of conditions that we feel necessary. So at least that's still available to us.
Especially if we're gonna tighten up the decision criteria too, that will also be helpful. But I think that parcel that you were talking about, Bob, is the post office there in Mesquite.
Really? That one on the east? Okay.
On the cul-de-sac?
Right. Is that correct, Sean?
What's that?
Is that the post office up there?
I believe so. Yes, ma'am.
So,
And that's,
Good customer base.
yeah. Mr. Chair, Commissioners, one thing on the D2, D2Ls, like the last case we heard with Mr. Tafoya. Oh, sorry. They're all residential. And so in Mr. Tafoya's case, he had a detached garage. So the detached garage was built under the residential building code as an accessory use in that instance. Now, he's been granted a micro business, which is converted to commercial. In that instance, the wiring
insulation, egress, lighting, things like that. When they get the special use permit granted, they don't really realize a lot that's going to take to convert that to a commercial application. The same with the gentleman with the outdoor grill before. He had the garage with the residence up above, so that's R3U. You can separate them to our firewall, again, the wiring. There's going to be a lot more that goes into that application form that they're not aware of, and that's what we're seeing on the building side that we're coming across. I have gone out to Mr. Tafoya's. His is a rare instance because he had the medical grow facility, and he was allowed to do that with no regulation through the state, and he did it through his garage. Now we're going to a micro business commercial. He's been growing in there for 10 years. Now all of a sudden, we're looking at throwing a lot more stuff that he's going to have to do to come into compliance with that. So that's a lot I see with the D2, D2L. If it's an outdoor, a separate building that he's going to do to grow in, or they're going to do, a little different on what we're doing because we're allowing a commercial application. We're talking egress pass to the street, everything that we'd look on a commercial application. And I think that really should be taken into consideration when you do an SUP, or at least we really need to educate them a little bit more on what they're applying for, because the state said, here you go, here's your license. So that's just some of the things I've noticed. Thank you.
Good analogy.
So it's fair game to talk about that to an applicant, isn't it? When they're just applying for a SUP or a rezone.
I believe everybody should be educated, yes, sir. I believe, especially because when you grant it, they think they have their license. Then all of a sudden, like when I spoke to both of the candidates afterwards, one gentleman was like, with the outdoor grow, was like, well, I don't know if I'm gonna be able to afford this now, when we're supposed to be doing economic development. There's things he can do, not use that building, build a separate building for his packaging manufacturing, but the outdoor grow is no problem. Mr. Tafoya, the same thing, and I'm doing a lot of research, trying to figure out, speaking to the electrical inspector, speaking to the state. He grew medical cannabis for 10 years in this facility, no issues, no mold.
Excuse me, Mr. Chair, but could he speak into a mic, please? I can't hear him.
Sorry, Commissioner Vargas, new to all this, so you guys got to forgive me. Going back to what I was saying is, the applicant should be made aware when they do the special use permit that it may trigger a lot more building additional requirements that they may not see coming. They think they're getting an SUP, they can grow cannabis in a hoop house, can they use a detached garage? What their requirements are before the SUP is granted, because you grant the SUP and then all of a sudden they realize, well, this is going to cost me $20,000 or $30,000 to update my facility to do what I want. And I think that's kind of going in contrast to what the Cannabis Control Division did for, economic growth. But it's just in the D2, D2L zones really because they're smaller lots with residential facilities.
So Sean, if they just put it in a hoop house, you don't regulate that, do you?
The hoop house, we still will permit.
You will?
Yes, sir. It's not required to be signed and sealed by an engineer, just the specs. A metal building, of course, will have to have an engineered stamp. But we're still going to be looking at all the commercial applications, an egress, exit light, a pathway to the outside, everything that comes in the building code. We're going to be looking at that, which on some of these, like for instance, at Foya's, you're putting a 4-foot walkway all the way to the outside. Stuff that they're not really thinking about, they're thinking about, I've got this opportunity, I've been granted a license, I've got the SUP permit. How much more money is it going to cost them?
And I guess the question now, Mr. Chair, is whose responsibility is this to have this conversation with the applicant? Is it ours as a commission during that special use permit hearing, or is it going to be put on staff to make sure and educate the applicant before they come before the commission?
Commissioners, both to a certain level. We always, of course, every case is going to be different.
Say every single property is going to be different.
For Mr. Mall and for the Tafoyas, they were advised, ahead of time to like, hey, one thing's to get the land use component taken care of. the second thing is gonna be, the building itself, if, what is it that you're ultimately planning on having on that property? And how is your operation gonna work? You really need to talk to building services, and some of them do, but it just, it depends on how deep they get into the conversation, because they might, Sean might be, laying out the whole book on them, and then all you're going to see is just yes, 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 yes. We are going to comply with it, and ultimately, it's when it actually comes time to submit the building permit, then that's when some of the issues might come up. That's not to say that we don't have people out there doing all their research right now. We do have people that have come in for multiple pre-apps to get everything, to get all their ducks in a row before submitting for an SUP or before submitting for a building permit. We do have those type of people out there, but we're also going to have those people that want to see if they're going to get the SUP first of all, before they can start going out there and maybe getting additional money or investors to help them out, finish up the whole project. So, it just depends on on the applicant's business plan.
So once they've filled out an application, paid the fee for an SUP, we can't, there's no way that we can consider whether they have the financial ability to pay for all the upgrades in the land use decision. Right. So it sounds to me like that's a staff function to make sure they understand. It's not just the fee, it's all this other stuff at the back end. Okay. All right.
Thank you.
Mr. Chair,
Yes.
I have a question for Sean. The question is, if somebody's going to be doing this commercially, it's going to be expensive. So would you recommend that they go in front of the DRC before they go to the community development?
Chair Costa, no, sir. I think that they should come to community development first, speak with planning on the zoning, and then really sit down with a more intensified plan on where they see their business going, so that we can direct them in the right way and let them know if it includes a property visit to see what they have or what they're proposing, what the requirements are going to be, or what they may be looking at, so we can lay it all out to them, so that they could make that decision if they want to move forward with the SUP. Or like when the commissioner said they want to, or Albert, they want to get the SUP first to see if they are going to be allowed to do it. Then they come in and go to building services. To me, I think it'd be better if they sat down with staff of building services personally, just so that we could lay everything out before they applied for the SUP, so that they're fully aware. We try to educate them. We say, like Albert said, we explain to them. But it's not till a lot of times we do a site visit and explain to them, you're going to have a 400-foot sidewalk, or you're going to have to redo the lighting inside of this building, the wiring, those things. Then it really hits home with them as opposed to just talking to them, sir.
All right, thank you.
Yes, sir.
Can we go on to the SUP criteria? Okay. Okay.
I made some slides and
Okay.
discussed together. So the next item, please, Felipe.
It's just a matrix.
Regarding the decisional criteria for SUPs, and this is across the board, it's not strictly for cannabis establishments, it's for all uses that will be applying for a special use permit. We've been having a flood of requests for solar farms. And the majority that will be coming forward will go through the special use permit process. So just to keep that in mind when we're looking at the decisional criteria. And Dr. Zerniak had quite a bit of input on on most of the amendments, actually. But the first being is that we're adding the word intensity to the definition. So in addition to looking at the scale and nature of the use, we also want to look at the intensity of the special use permit that it will have on the neighborhood, if it'll have a major negative impact or not. Any questions on that? Okay. Okay, so for special use permits, an applicant has the option of applying for an administrative SUP or proceeding directly to the Planning and Zoning Commission for a public hearing. And what staff is proposing is that if there's a code violation on the property, we want to tell the applicant that the administrative process is not an option. You need to go directly to the Planning and Zoning Commission because we've received complaints from the neighborhood and we know that there's concerns. So we're actually proposing the amendment that's in red that if there is a code violation on the property, that staff may require the applicant to proceed directly to a public hearing. And then Albert and I were talking about this further, and we were thinking that staff should have the discretion, period, whether or not there's a code violation on the property. If we feel that this is a very high intense use, that the neighborhood is going to be really affected by it, we feel that it should go to a public hearing rather than go through the administrative process. Because if we don't get any complaints from the neighborhood, then it's automatically approved for a special use permit on the administrative level.
So the way this is written, if there is a code violation, you don't have any discretion. It automatically goes to a public hearing.
No.
And you're saying that you want to have that discretion?
We want to have that discretion to tell them you have to go up to a public hearing immediately. Right.
The way it's written right now, it automatically goes to administrative approval.
Well, they have the option. But it's generally faster if it goes through an administrative.
Let's back up. Sean, you're going to need to get into this conversation. If there's a code violation on a parcel, why don't you make them correct the code violation before it comes to, before you can even consider it for an SUP? Let me just finish. I don't understand why you're asking the commission to resolve that issue.
Mr. Chair, I'm sorry. I want to make one point before you speak, before you answer. Because we have had cases in the past where the disposition of code violation is really determined by our ruling.
Right, and I was going to make that point. I mean, whether or not they have a violation is separate. I mean, in some cases, the only remedy is coming to this board.
Give me an example.
You know, I'll use an example that came forward recently, and that was the man who had a mechanic's garage on his property. And it had been in violation for many years. And we finally were able to bring it forward for consideration. In that case, staff was recommending denial because it was not a compatible use. But he still had the right to make the application and come before you. What you were looking at was the land use. Is this appropriate? Whether or not he had a violation was a separate issue. He could have come in here without a violation, planning to do something like that, and said, I want to apply, even if it's unlikely.
Right.
So, you know, the fact that he had a violation was separate. He took his right to come here, but the land use was really what we were looking at. Is this a compatible use? It was not, and the determination was to deny it. In some cases, you might have a violation. Their only remedy, the only way they can correct it, is to come in and apply and come before the public hearing. Staff will always only be looking at whether or not it's a compatible land use, and we will be looking at the criteria for whether or not that land use is appropriate. If they have a violation, that's really not what staff is looking at. That's a separate issue. We always inform you if they have a violation, but if they can only correct it by coming before this commission, then that's really what we are required to do.
So if you say you recommend denial on a case like that because the land use isn't appropriate, we say no, the BOCC says no, what happens?
They are required to correct the situation. That particular case with the mechanic shop, he continued to operate until we threatened to pull the power from the property. And that's a very extreme situation because the power was tied to the residents. So we don't prefer to do that, but sometimes that's the only corrective action that will result in action. And so he finally did move out his business. So now it is in compliance.
Mr. Chair,
Yes.
I have a question for Commissioner Thurston. Do you remember a while back when this person up there in the East Mesa was, had a mechanic shop adjacent to a mobile home? Do you remember that?
On the East Mesa,
Yeah. And we denied that. And this is a perfect example, a mechanic shop, but I don't know if he met all the requirements that the county required. Do you remember that? And you and I discussed that after the case. It said, we just denied a person from having their business.
yes.
Whatever happened on that case?
I think this
Is
is.
this like the one that
I think
Christine
that's
is
what she's referring
describing?
I think that's what she's referred to right now.
Okay.
Christina said that they threatened to turn the power off, so the guy moved his business.
Uh-huh. All right, thank you.
So I understand that. The problem I have is the minute I see those words in an application, I have a negative response to them. And I think you're telling me I shouldn't.
Well, I mean, I understand that, but you know, the way the code enforcement process works is they're put on notice by the code enforcement officers. If there's no action by the property owner, then we end up in court. And so the court will usually tell them to exercise all their options before they make a decision. So that might mean that they have to apply for either a rezoning or a special use permit, and they have to go through all of that before we can go back to the court, and the court will finally make a ruling. And that's what happened in this case. It ended up back in court. The court said, you can't have that business. You were not able to get the special use permit. You must vacate that business. And so that court action still wasn't effective enough. We had to take the extreme measure of threatening to turn off the power for him to finally realize, hey, this can't continue. So those are the steps that we go through in code enforcement. We try to go through the route of notifying and trying to obtain willing participation in correcting the actions, but that doesn't always happen. So there's a lengthy process that follows, typically through the court system, which will kick it back through zoning approvals if that's the only remedy or potential remedy. That doesn't mean that the use is appropriate. In some cases, it's not. In many cases, it's not. But if it is appropriate, then staff will not be looking at whether or not there's violations. We will only be looking at the land use and whether it's compatible. We have to make you aware if there are violations, obviously. But what we are, I guess what we're requesting is that you look strictly at the land use component. If there are additional conditions that can be placed on it to, I guess, soften that use, that's all related to the land use, not because it's in violation. They are going to have to correct any violations if they can't be remedied through a special use permit or a rezoning. They will still have to correct those. But we have to go through this process regardless.
So if there is an alternative to correcting the code violation other than the SUP, do you go to them and say, you know, you should correct this first before you go in front of the commission?
Yes. Yes. I mean, if there's other issues, like they built a storage building without a permit or something like that, we request that they go ahead and apply for that building permit if it can be applied for. If they do something that violates a setback, then we're not going to be able to issue them a permit. They're still going to have to come here. So those corrective actions, we try to make sure that they're at least initiated before we come here, if they can be.
I have a question. I think I know the answer, but I'm going to ask it. Sometimes the staff will ask for a conditional approval of an SUP. Is it within the authority of this commission to make one of those conditions the correction of the violation prior to the SUP being granted?
It really depends on the violation. I mean, if it's a violation that can't really be corrected unless the SUP is approved, then I would say it's not appropriate. If they're coming in with something that obviously could have been corrected, they just didn't do it, then I would say that that's appropriate direction to take. You need to correct that before you can commence your SUP.
So can we make that, is it okay to make that part of the staff's recommendation?
I think we can. I mean, if there is a scenario like that, I mean, each one is different. You know, there's different varieties of violations that could be occurring, but if we arrive at a point where they haven't corrected any of them and some could have been, then, you know, we can make that recommendation.
Okay.
Mr. Chair, I want to bring up a recent case where, you know, we ruled on a church that, you know, that's what I'm thinking of, the grading issue. So, Christine, you would recommend that it would have to be a staff recommendation for them to cure the grading issues and not a planning and zoning recommendation or planning and zoning condition, you know, to grant that special use permit?
I mean, that's a good example because, I mean, the grading was a separate issue. They should have obtained a grading permit before they did any work. But it's kind of a tricky one because they really couldn't have applied for a grading permit for the use that they wanted until they had an approval for that land use. I mean, you don't typically just apply for a grading permit with no potential use on there, and that was the issue. They were notified that they shouldn't have been doing that, but they couldn't apply for a permit, and so no corrective action had taken place at that point. We learned after the fact that, you know, the silt fence was not appropriate. It's not an appropriate method to contain the dust. And so we're kind of in a, you know, we're trying to get corrective action, but it hasn't occurred.
Can't ungrade the property.
Right. But it really all hinges on them being able to develop that property in order to properly correct it. I mean, the other option would be to replant, which, I mean, they're not going to do.
Yeah.
So, I mean, some of those are tricky. We can arrive at some corrective measure, but it might not be the full compliance until we have a resolution to whether or not the land use is going to be allowed.
No, I think it would, if I may, Steve, I think it would be helpful if staff would tell us that we're using the SUP as part of the corrective measure, so that we don't hold it against them. That's my problem.
And that's the reason I brought that up in that case, is that we approved that with our, it sounded like it was our condition as a P&Z commission instead of a staff recommendation.
Yeah.
And I think that's what we're trying to avoid. Am I correct? Is that what we're trying to avoid?
And I mean, not because it's not appropriate for you to want to include conditions like that, but primarily because that corrective action has to take place regardless. It's in an ordinance, and so that really is what dictates what needs to be done. They are going to have to correct the action, regardless of whether or not their land use is approved. If it's not approved, then we take a different route for them to comply.
Yeah. Okay.
And I appreciate what Dr. Zerniak is pointing out. It's very hard for us to continue with this really positive attitude when we see these violations. And we try. I mean, I do believe we try, and we do have to ask, and we do have to address. But we don't want the applicant going into this as I don't want to say guilty until proven until innocent, but it is something that we're holding against them, you know, before they've, even before they've set foot in here to state their case on their special use permit request.
Okay, so we may tweak this language a little bit if we have your support, with giving us the discretion of telling them public hearing instead of administrative. Okay. Okay. So then the next recommendation has to do with the application procedures, and that's in item 5. And we're requesting that we may ask for additional analyses or data, and that the applicant shall pay for it at their own expense. Okay, that's just a little clarification. All righty. Okay, so then, this is just a clarification regarding the posting and the notice procedures. An applicant has to post signage on the property for 21 days, and we're just stating that they also have to maintain it for that 21-day period.
So just a quick comment.
Uh-huh.
I've driven past properties that are coming up over the years, and the problem I have with the signage that the county uses is that the lettering is so small. The only way you can read it is if you go onto the property, and that's obviously a problem, because I'm not supposed to do that, I know that, and neither is anybody else, right? So it seems to me that, and I don't know exactly how you do this or who could help you with this, but if you assume that a sign is going to be 20 feet from the roadway or 15 feet from the roadway, what's the minimum font size that you should be using that somebody could read it from the roadway? I mean, I've even seen a typed page smacked up there like this, right? That makes no sense. That's not a public notice. That's not a public notice. And I think it's unfair to the community and to ask them to go on the property to read the sign. So that's just an observation.
Let me make a comment about that. First of all, there's, like you said, there could be a page like this up on a board. So there's quite a bit of information on that. So in order to make it the font size large enough that you could read it as you're driving by or walking by or something, we're talking almost like a billboard. I mean, it's going to have to be pretty big. Okay. So I'm wondering if you could do something like real estate people do, where you have a box with flyers in it, where a public could pull out a sheet and take it with them that would have the information that would be on that sign.
Just if that's an added expense, the applicant pays for it.
Yeah. But that way, I think you could avoid people going on the property, but you would still, they would have public access to it. They could pull one of those flyers out, take it with them, and read it whenever they wanted to. And obviously would have contact information for the staff for them to, if they had any questions. But, yeah, I just, the expense of putting up a sign big enough that you could read would be horrendous.
So the only thing that the sign might say is rezoning request or SUP request.
Yes.
And the lettering would be fairly
Yes,
rough.
right.
I'm just asking you to think about that.
Mm-hmm. And we can also ask them to put it on the property line, because the way it's written is that they have 21 days to post the sign on the subject property in conspicuous locations in a manner that is reasonably calculated to notify adjacent property owners and passers-by of the hearing for the proposed special use permit. So we can maybe add at the property line. Because we do try but yeah, it's difficult. Sometimes you do have to get out of your car and read exactly what's being proposed. Or call the community development department. Okay. All right, then the next proposal is the decisional criteria itself. So for a proposed SUP, we're changing the word must to shall. It shall be consistent with the public health, safety, and general welfare of the residents of the county per this chapter. And then we further state that the zoning administrator, P&Z, BOCC shall use the following general criteria, and then we're adding the language, and may require that additional information be presented, again, when reviewing special use permits. And then we're adding that the burden of proof shall rest solely with the applicant and shall clearly demonstrate how the proposed SUP shall meet the following decisional criteria. And they're not limited to the following. For potential traffic flows and impacts, we're proposing to add 2 items that they demonstrate that the measures are adequate to accommodate the ingress and egress to avoid congestion, impede surrounding traffic flows, or create hazardous or unsafe conditions. I think that's pretty conclusive on traffic. And then additionally, that the proposed SUP contains sufficient off-street parking and loading facilities that will be developed in accordance with the requirements of the chapter. So they have to comply with the development standards as well.
I have a question on that. Who is going to be the judge of the documents that are given to you? Because, for example, you're saying for egress. Well, in my eyes, maybe I only need A and B, but in your eyes, you got to have C, D, and E, and F. Who is going to be the judge and jury on my submittal? So let's take the church situation over on, what is the name of that street?
Marina?
Webb and Marino.
Yeah.
Okay,
Marina.
so we're in the presentation of that one, you asked for a
TIA?
TIA. So in order to do an analysis of what you're asking there, at what level are you going to require a TIA? Or are you just going to allow the applicant to say, under my discretion, I have adequate ingress, egress, and show you a map and kind of what I'm going to do or not going to do? Or are you going to force them to go and spend the money on a TIA to create that information? And the off-street parking and the on-street parking and all of that kind of stuff, that's going to be more or less addressed. But if I'm the applicant of a situation, I'm not going to want to spend that $10,000, $12,000.
Remember.
So help me out.
Go up to the one before that. The burden of proof shall rest solely with the applicant. It's your job as the applicant to prove to staff and to the commission that you've addressed that requirement.
Okay, so if I've addressed that in my application to staff and to the commission without a certified stamp, you're okay.
That the staff will make, and we'll make that decision. That's part of our decisional criteria.
Okay. As a user of the system, I would not want that to be forced upon me to have a traffic engineer to comply with that requirement right there. So as long as it's the applicant that is doing his best to show what he's trying to do, I'm okay with that.
And that's how it's been historically. The applicant has submitted bare bone information.
Okay.
Now, if it's a major commercial use, we do require the STA, and that will determine if a traffic impact analysis is required. But initially, the applicant should provide this minimum information to give staff as well as other departments exactly how they're going to provide for parking, ingress and egress, what type of traffic that they're proposing.
Gotcha.
And if engineering determines that a TIA is required, then that would be the next step. Okay? Any other comments on this one? Then the second item would be that they need to demonstrate that there is a public need for the new commercial or residential activity and how it complies with Plan 2040. We've really neglected analyzing the comprehensive plan for special use permits. We do for zone changes, but not special use permits. So we would definitely assist the applicant on where to look and get that information, but we're asking that they do address the public need for this use.
I have a question about that. What's the criteria for public need? I mean, would it have to be a survey of residents, or how would I demonstrate a need for what I wanted to do in a residential area?
That's a good question. Because the way it's written now, it just says the need for the new. And now we're asking them to further explain the public need. So for instance, let's see the church. there's not a church within 2 miles of this location, or our congregation principally lives in this neighborhood.
Okay.
You know, that type of information, just,
So like the rest of it's kind of a case-by-case thing.
exactly,
Always,
right.
yeah.
So Commissioner, that's really just putting the, I don't want to call it the burden of proof, but it's really putting that on the applicant to demonstrate the need, and not the county staff or the commission.
Right.
And with their submittal, we do ask for a narrative and a scope of operation, and I think this would also help them with their narrative as well. Going into greater detail, because right now it is fairly minimum.
Question. How do I convince you, the county, that my residential need is necessary?
Well, you wouldn't use a SUP for a residential,
Well, then why is it in there?
because this is for special use permits.
For residential activity?
Does say residential.
This could be for a
What do you mean it doesn't apply?
multifamily development or even accessory living quarters. That's why residential is still in there. Not all the SUPs are commercial.
Okay. How would you prove it?
Well, that was my question.
No, that's your problem as the applicant. How do you prove that you need to, I mean, if it's an accessory use,
Yeah, then there
Say-
wouldn't be a public need.
yeah. Or if you wanted to put, say, a granny apartment in, right? There might be a public need for that because there's no place else for your grandmother to live. Or you,
Well, the part that's coming into my mind is that one we just had out on, what was it, Snow Road, or where they were having
The group home,
the group home.
Group home, yeah.
I mean, did they not present a need?
well, just because there's a need doesn't mean that it's justified.
Well, I understand, but
Yeah.
that's what I'm asking. What the public need, how am I going to meet that criteria to even get into a submittal in front of you guys? The public need for the new commercial or residential, a new commercial only? Or new residential activity only?
Oh, I see, you want to drop the word new?
I don't,
I mean, I don't think it makes,
if I'm presenting a subdivision, or John or Billy Boy is presenting a subdivision and chooses to go through the SUP because he didn't like certain criteria in the regular zone, how, the public need?
you'd have to show population growth, that there was a demand. I mean, you wouldn't build it if there wasn't a need.
Oh, but I'm the applicant.
No, I understand.
now
But the way,
presenting it to you guys.
the way you would present that to us is to show your market analysis.
Yeah.
That's the way you would do it.
Okay.
There's a demand for housing. That's a public need.
And that, okay,
That's all you'd have to do, is show the demand. And you would do that anyway, because you wouldn't do it if there wasn't a demand. That by definition is a public need.
all right. And then how it complies to Plan 2040,
Right.
okay?
okay. And then regarding the potential water and sewer needs, we're also asking that they submit supporting documentation showing that the infrastructure is available to support the proposed use. So if they are on a septic tank, we'll need the septic tank permit that will show the addition, the expansion from commercial to a residential use, and that there is water available. Okay? Okay, moving along for item 4, regarding existing infrastructure. So we're asking that the applicant demonstrate the extent to which the capacity of the existing infrastructure, as well as the public, we're adding public facilities and services are available. And if they're adequate to meet the demand generated by the proposed use. and if they can accommodate the new development. And we may want to eliminate, delete new development as well and just call it development.
Okay.
Any questions there? Okay, then the next item is regarding environmentally sensitive areas. If they are within the proposed area, we're asking the applicant to demonstrate how the SUP will mitigate these species or
I think you could just say
environment,
mitigate the affected areas.
not these, the, mitigate the affected
Thank you,
areas?
Steve.
What did you just suggest?
Oh, the affected areas.
Yeah, it was just that, I think the wording, instead of saying these areas if affected, it's the affected areas.
Mitigate these, if applicable, if we wanted to add that phrase. Okay, and then finally, regarding the impact of the proposed SUP on the surrounding areas, we're also asking them to demonstrate or to show how it will be a positive impact on the adjacent properties, and it will not be detrimental to the public health, safety, or general welfare of the neighboring properties.
I have a question on that one. So the way I read that is, I'll use an example, a recent one we had with the church. We had a significant negative response from the neighborhood. So the way I'm reading this or interpreting this means that we would take that into account in making our decision. Is that correct?
Yep.
Okay.
Yep, absolutely.
And it says, I'll have another point, it says provides a positive impact.
Right.
What if it's just a neutral impact? What if there's not really much impact at all? I mean, do they have to prove that it's a positive impact or just that it has no negative impact?
No, I think they have to show, with that wording, they have to show that in particular, the neighborhood will be better off as a result of the development.
Because we always look at the
The negative.
negativity associated with the use.
Right.
So,
Okay.
and the applicant is always the one who's real positive about it.
Right.
But we only hear about it in the hearing.
Yeah.
We don't get it in their narrative or anything, so.
Okay. All right. Thank you.
Okay,
Can I ask a question on that one?
yes.
Okay, so the applicant gets up and he says, here, I'm gonna try to do this and this and this, and it's gonna be a positive impact to the area. But that positive impact by the church is subjective.
Exactly.
It's always subjective, it's all,
So the applicant has to be the positive person.
right, right. I mean, if you think about it, all of it's a balancing test, one against the other. That's what you're always doing. And trying to figure out if, in general, if it's allowable under the code, and then, because there's usually neighborhood opposition, whether or not the balance between the two, the pros and the cons, that the neighborhood is better off in the end with it than without it. So it's those two things. So,
Okay.
yeah. And I think asking the applicant to show that this location is better off and the neighborhood's better off is a fair question to ask.
Gotcha.
Okay. All righty. Then the next item has to do with approval procedures and conditions. And Dr. Zerniak is the one who actually came up with this language and asked that we insert that the SUP shall not be considered as establishing a binding precedent to grant other special use permits. I mean, generally it's a given, but I think that, you know, it's on a case-by-case basis, and we're just having it in the code.
So
Mr. Chair,
we have to give you the attaboy on
Boy. Do you want to initial that for me?
Chair,
that? I think Mel's wants to talk.
Mel,
the word president has come up in the past.
right.
And Joseph Cervantes at one time got on us because he says, give me case law on presidents.
I don't remember what the situation was, but we don't give anybody case law. If he's got a legal question, you go to legal, not to the planning commission.
But using that word president it leads to the probability of litigation as we go down the line.
Mel, the purpose of that.
Synonym.
The purpose of that is to make it clear that every SUP is on a case-by-case basis.
Well, then that's what we should say.
Well, that's what
we
we're
should say,
saying.
Glenn.
And that a previous decision doesn't bind or doesn't lock the commission into making the same decision again. That's the
But I
key.
mean, we should spell it out to say it's on a case-by-case basis, you know? I mean, that's what we've been doing anyway.
I think this is pretty clear, though.
Yeah.
I think the way it's written.
I agree.
I mean, we can add the phrase at the end and is viewed on a case-by-case basis.
Fine.
Yep. Do you think so, or
I think it's
it's clear enough? Okay.
It's kind of redundant.
Yeah.
Okay, and then our final recommendation is when we're recording the special use permit, we're just also adding that we include other information, including the conditions. The way the code is written now, it says other provisions, and we're just adding the word condition, because that's generally what the Planning and Zoning Commission does, places conditions on a special use permit.
Can you go back to the decision criteria for a second? It is,
Which section?
next one. Yeah. So this number 7, I have never heard the staff or the applicant tell us what best management practices are going to be used for the development. I mean, so what does that mean? Do we actually have a section in the code that says these are the best management practices for grading, for landscaping? Otherwise, what does that mean?
There is a definition. Help me out, Albert. Because I know this has to do with like rain harvesting and landscaping and.
And I'll just read it off of the UDC. So best management practice, BMP, schedule of activities, prohibitions of practices, maintenance procedures, and other management practices to prevent or reduce the discharge of pollutants to the MS4 and waters of the US BMPs. Also include treatment requirements, operating procedures, and practices to control fugitive dust, site runoff, spillage or leaks, sludge or waste disposal, drainage from raw material storage, and other site development work that optimizes resources.
So that's actually a really loaded statement. I mean, is that, first of all, how do you evaluate that? If this is a decisional criteria, how do you evaluate number 7 vis-a-vis the application? That what you're saying is they're going to do this, but that's not enforceable. It's not generally enforceable. Nobody's going out to check on a regular basis to make sure. Because if they don't use the best management practices, you should be able to either stop the SUP, revoke it, but that's never happened as far as I know.
Yeah, and a lot of this, it's probably not enforceable during the SUP stage. I think it mostly has to do with the building permitting stage and making sure that everything is being built out to, the code, and, following those BMPs that are in there.
So within the context of the land use, are there certain best management practices from the definition that we could pull out?
One of the components that typically applicants submit or are required to submit, especially for commercial uses, is a site plan. So we can look at that and make sure that, yes, there is, grading and drainage happening in there, that they're also going to be mitigating dust control and that kind of stuff. I mean, those are kind of some of the things that I'm thinking about just off the top of my head.
So should we say those things rather than a generic statement about best management practices? And in turn, what my concern is that it be specific to the land use.
Mm-hmm.
I don't know. I mean, that's something.
We could somehow tie that to the site plan requirement.
Okay.
We could probably just have to wordsmith some language in there.
Okay. I want it to be so that when the applicant, when they put their application in, they know what they're applying for.
Mm-hmm.
And that you have some criteria to evaluate it against.
Yes.
Right? Because that's too generic as it's written. I didn't realize that definition was so complicated either. So maybe take a crack at that.
Tie it to the site plan component. Okay, we'll further look at that. Okay, so that concludes staff's recommendations. Did you have anything further? Okay, we did that.
No.
Janine,
Mel?
Mr. Chair, yeah. Chairman Zerniak stated that we had never had a case regarding best management practices, but I remember way back that we had a gentleman that actually basically drafted landscaping and things of this nature. What was his name? I can't remember offhand. And he came from the city of El Paso, coming to regarding landscaping and curb gutter, and then it went into the
David Christiani?
yes, right.
Okay.
And we had a couple of warehouses up in Santa Teresa. I remember. So there was a case there regarding best management practices, and I think that's where it originated.
I'm okay with that, Mel. I just want to make sure that we tie the best management practices to the land use because that's our concern.
Right.
Okay. Thank you, Janine.
Okay, thank you. So,
Anything else?
I have one question. It's down south in, what's the airport?
Santa Teresa? No, not Santa Teresa.
No, I think it's called the Doniana Airport or something. Isn't that what it's called? The gym part?
Jetport.
Oh, the jet port. And then all of the industrial complexes there, is that all in our Doniana County?
Yep.
But do we ever get involved in any of those decisions on zoning and like on the bill?
We don't
Part that
because
I've been here, I
it's
just
in the
not-
CRUA jurisdiction, the Camino
So
Real
it's not
Regional
in the
Utility.
Doniana.
No, they have planning authority. The CRUA board does.
And what does ACRUA stand for?
It's the Camino Real Regional Utility Authority. And there's a joint powers agreement with Sunland Park that the county has. Because it's in their extraterritorial jurisdiction, Sunland Parks. And so I wasn't here when that happened, but they agreed to allow the utility to be formed. And then somebody threw in the planning authority to that agency. And it's a 20-year agreement, which is currently being reevaluated by the county and Sunland Park.
Is it coming up?
Yes, within, I would say probably sometime this year, we'll hopefully have some resolution. But the county would like to apply our zoning ordinance to that area. Currently, they're on our old zoning ordinance. And so that requires staff to, because we still administer the ordinance, it requires staff to have, to be knowledgeable in two ordinances because we apply that old ordinance over there. And so the county would like to have uniformity throughout the county and use only the ordinance that the county is currently using.
So if I'm asked to go down and put a bid, for example, on a building there, do I go to, I didn't even know how to answer his question. Do I go to Doñana County for the building permit by the airport?
Yes.
For a industrial building?
Yes, you would still come to the
Or do I go
county.
to what you just said?
No, you would still come to the county. The county still administers everything. The building permit authority is still the county's. It's only planning authority that CRUA has, but we also administer those applications. So if somebody wants to do a zone change or a variance in the CRUA area, they still come to the county and apply. The only difference is that we use the old ordinance and any decisions are made by the CRUA P&Z and the CRUA board.
Okay.
Mr. Chair,
Yes, Mel?
on the JPA, is there a statute of limitations on that?
That, it's a 20-year agreement. And I don't know offhand how long ago it was approved, but I think it still has about, 13 to 15 years, I'm not sure. But it is currently being reevaluated for other reasons. And I don't know what the outcome is going to be, but one potential outcome may be that the planning authority comes back to the county. We'll just have to see what happens in the next few months.
Is it gonna go to litigation or what?
It's not in litigation. Some of the details I know are that CRUA was pushing to have the utility authority created through the legislature so that it takes away the joint powers agreement. And the reason for that was because they have long-term loans. And it's difficult to get long-term loans if you only have a 20-year agreement. However, the county and Sunland Park were not in favor of a move like that, which is what I understand. So there are a couple of options. One would be to extend the agreement and maybe change some of the authority. And the other option would be to abolish it and redistribute that utility authority to one of the agencies and then determine who will have planning authority. The county would like to have planning authority.
Wouldn't the city of Sunland Park be able to annex that area?
They do. They annex land there all the time, and when they do that, then it's now under the jurisdiction of Sunland Park.
Yeah, but they have to have permission of the property owners, don't they?
Right. It's by petition, and
Yeah.
so, and they've had several annexation cases recently. Whenever they annex land, then it's no longer administered by us, and it goes to the city of Sunland Park.
So is the land there at the airport where those buildings are, is that annexed by Sunland?
No,
or
that's
in the-
currently, that's unincorporated
So
county.
the permit goes through here,
Yes,
you inspect. Okay.
yes.
CRUA is a utility. Do they do water and sewer?
Yes, they do.
But, and then when that was set up, McCamley cut this deal.
Who did?
Bill McCamley, when he was a
Okay.
commissioner.
Yeah.
And I don't know why they threw in the land use component. I never understood that. But that's the real rub in all this, because the county do they pay the county to do that?
They do.
Yeah, so county staff does all the work. And then there's a P&Z and a CRUA board. which is the equivalent of us and the BOCC, and they make the decisions for land use.
The guy, I just didn't even know how to go, because I got he's saying to go to Sunland Park. And I'm going, no, I think that's Doñana, but I
Yeah.
didn't know that the separation, I don't know how the separation is. But a building permit for a 40 by 50 building goes through here,
Yes.
okay. But it sounds
And the
like-
question I have, Mr. Chair, is what happens to the utilities and what happens to the water rights and all of that? If the JPA was to no longer be valid?
Well, the Sunland Park and the county would have to agree on what to do. It could go back to the county, it could go back to Sunland Park, they could split it like it used to be. But that's something that they would have to negotiate.
That's why CRUA was created, because they
That's
couldn't
correct.
agree.
But I understand now they're seeing eye to eye on what they want to do.
It just seemed like Luis gave us a presentation on a deal down there, and I haven't figured it out yet, but
Yeah.
I got approached on that, so I needed to find out myself, so.
Are we good? Mel, you done?
Yeah, I have a lot of questions, but I'll call on that.
Bill, are you still with us?
Yeah, I'm still here. I'm just listening.
Okay,
I'm good.
okay, I think we're done, huh? Okay.
Oh, and then, four commissioners' terms expire at the end of April. Mr. Lear, Mr. Thurston, Montañez, and Acosta. So, we will be recruiting, with an application of deadline of April 8th. So if you're interested in reapplying, please submit the information. And we'll send out a press release and whatnot, and the Board of County Commissioners will make the decision on April 26th.
Mel, did you hear that?
I couldn't hear it.
Your term of office is up. You need to reapply.
Yeah. Okay, I'll re-up.
And then just send them to my email and that'll be on the press release.
I'll send you all the press release.
All right.
Who else's terms up?
It's just a letter of intent.
I couldn't hear that, Mr. Chair.
Mr. Chair, we need to get a mic
Get your
over there.
microphone,
We can't
please.
hear.
It's Commissioner Thurston, Commissioner Lear, Commissioner Montañez, and Commissioner Acosta.
Okay, I got it.
Apply by April 8th, Janine says.
All right.
Okay? I think we're adjourned.
There's a Love's truck stop down there now. At the
Yeah.